Now the question for the future is whether we will continue to see the European Union becoming a direct actor in the field of international human rights. That is to say, a party to the negotiation, ratification of new human rights instruments, or indeed of ratification of existing human rights instruments that have come very much within the scope of activity of the European Union. One could think, for example, of the international conventions, both at the UN and Council of Europe level, on the rights of migrant workers. Let me then come to the 5 specific points I wanted to make about the institutional dimension of fundamental rights. The first is related to the question of accession to the European Convention, which Jean-Paul has treated in detail and in depth. What struck me is, and what I didn't know, is that he seemed to allude to the fact that the Court of Justice might be a source of problems here. Again, I would say. My second point relates to the Charter. And Jean-Paul hasn't spoken much about the EU Charter, but he has dealt with it in his written paper. And that's, of course, the most spectacular change of the Lisbon Treaty compared to the existing laws, is that the Charter of Fundamental Rights now becomes part of primary law. In his paper, Jean-Paul Jacquet explains that this concern of the member states that the Charter would lead to an expansion of the competences of the European Union is really misplaced, because fundamental rights are not about attributing new competences, they're about a standard to be respected in exercising existing competences. The Charter has always been very clear on that point. It's been now repeated, it's been hammered in the Lisbon Treaty, but it has always been clear. So that's a false problem. I fully agree with that. But there is an issue which is slightly different, but which is perhaps a legitimate source of concern for the member states, is that the Charter, in its Article 51, imposes an obligation on the member states and the Union to not only to respect the fundamental rights in the Charter, but also to promote the application of the rights contained in it. My third point is about minority rights. Why minority rights? Because the Lisbon Treaty, in fact, has introduced a reference to the rights of minorities into the texts of the Treaty on European Union in Article 2. This reference was not in the draft constitution of the convention, but was introduced in the IGC, leading to the constitutional treaty, on a request, I think, of the Hungarian government, and it was introduced then. Now, the problem with minority rights is that we don't exactly know what these rights are. Unlike the other human rights, which are spelled out elsewhere in the treaties or in the Charter of Rights, here we don't know what this reference means, because the Charter of Rights has no article on minority rights. And that leads me to the agency, which is my fourth point. The Fundamental Rights Agency, as we know, was established in 2007 under the earlier treaty, on the basis of Article 308 EC Treaty. And its existence and functions are not directly affected by the Treaty of Lisbon, except on one point, I think. And that one point relates to the subject of this afternoon, to the third pillar, in the sense that the existing regulation of the agency in its Article 3 excludes the role of the agency for what was the third pillar. It restricts the activities of the agency to community law. That's the way it's done. And that was in order to prevent the agency from interfering with the second and especially the third pillar, which is curious because these are areas in which fundamental rights are particularly sensitive. So that was a sort of understandable, if you know the political context, but certainly strange restriction in the scope of activity of the agency. My last point, fifth and last point, is, and this is not really directly linked to the Lisbon Treaty, is a new development of the last year, years is that the community, and now the Union, has become a party to human rights treaties. That hadn't happened before, but what we've seen a few years ago, in 2006, is that the community helped to negotiate, to sign, and later to ratify the UN Convention on the Rights of Persons with Disabilities. The competence of the community to conclude the convention was based on the Articles 13 and 95 of the EC Treaty, therefore connecting the Convention on Disabilities with the anti-discrimination policy of the EC and with the internal market competences of the EC. Now, ratification of this instrument, which was decided very recently by the Council, not only means that the Convention has binding effect for the European Union institutions, and possibly direct effect in the EU and national legal orders, but also the fact that the Union is now submitted to an international monitoring mechanism directly, namely the monitoring mechanism set in place by the Disability Convention.